That report came out on October 13th, 2022, not 2023. Probably a better thing that he got rid of this attorney. Somebody is lying about what happened to Kiely, that she was very, very real, and someone very, very real is out there with the very, very real truth and needs to be serving some very, very real prison time. Hey guys, this is Jules with True Crime Reactions. Disclaimer, everything stated in this video is my opinion and my opinion only. And just like everything else in these cases we discuss here on this channel, everything is alleged. All right, I told you guys in this video here that we were going to go over all 27 pages of Ryan Upchurch's motion to dismiss when it came to the defamation lawsuit that was filed against him by Kiely Rodni's father and grandfather. Now, again, Lindsay, who is Kiely's mother, that a lot of people, myself included, have issues with certain things, is not listed in this lawsuit. But I will say, and I will continue to say, there were a lot of things that should not have happened in this case. Do I think that her parents, her step parents, her grandfather, her biological parents have anything to do with what happened to her? No, I do not. If you've been here for a long time, you know exactly who I think is lying and who I'm anxiously waiting to get some more information about. But besides the fact that Lindsay should have not fallen asleep and made sure that she was awake when her daughter got home, to where if it was a little bit longer than it should have been, she was constantly calling. Maybe the cops could have gotten called faster, but instead she was asleep. She fell asleep before Kiely got home. And there was a text message about the instant change of plan, this last minute change of plan, because remember, Kiely was supposed to go to a car show with her family, but then got a text message sent off to her mom about now going to this party. There wasn't voice communication. It was all through text message. And in my opinion, unless you've heard someone's voice, a text message and a phone ping doesn't mean anything. All of those things are mobile and can be done by other people. So those things have always, always, always bothered me, but I still do not believe that they had anything to do with what happened to her. So in saying that, I'm not in agreement with the way that Ryan Upchurch went about things. Just like in the Idaho 4 case, I can believe that there's a lot of questions. I can have my own issues when it comes to who is serving a freaking life sentence right now, okay? And still not be okay with the way that certain people come about doing certain things, even if they are on the same side that I am on. I have a fine line that I like to walk. I will ask questions. I will take what is factual, something that has a receipt, something I can pull a clip of the person saying it themselves and base an opinion off of that. But to make things up, to fabricate things, that's not okay, especially when you are dragging a family through more of a process than you need to because you have no substantive evidence to back anything up. You are basically sitting here and just wasting time for what? There's nothing important being asked for. What do Daniel's medical records have to do with Kiely Rodni's death? Literally absolutely nothing. So I don't really know what the point of this entire thing is, but I'm determined to find out and see what's going on to the very end. Just like we're still waiting on more information about what really happened to her. There's reports that I'm still waiting on, and I have a feeling that since everything from CHP has already been put out there and her car has been auctioned off, that there should be some updated information somewhere. Hopefully we get something. I don't know. I have specific things that I have asked for, so fingers crossed. Now again, this is 27 pages. This was posted back on 10/10 of 23. And there wasn't supposed to be any sort of trial or anything happening until August of 2025. So already this case was being pushed back by like 2 years from filing to going to trial. But now that there's been changes of attorneys for Ryan Upchurch, the trial that was supposed to happen in August got pushed back to December for other reasons. But now the December 2nd, 2025 one has now been pushed back to, we don't have a date yet. I checked the website earlier today. I'm recording this on 11/21/2025. It's around 8:45 p.m. Texas time, and they still do not have a date. So I'm going to assume the pretrial conference that's going to be happening here in a few days on Monday, 11/24, There should be a date given then or shortly after. I don't see why there wouldn't be. But let's go ahead and read the motion to dismiss. We've gone through the original 40-something page amended complaint that was filed. We have not gone over this, so this is going to be a new one for me. I've not read this entire thing. Let's see what they have to say for why they wanted this defamation lawsuit dismissed. Mr. Upchurch respectfully requests that the court dismiss the case with prejudice pursuant to Rule 12b6 of the Federal Rules of Civil Procedure. 1. Facts alleged in the amended complaint, and there's a footnote. As required, allegations in the amended complaint, doc number 9, are accepted as true for the purposes of this motion. Okay. This case involves alleged statements Mr. Upchurch made in videos posted on YouTube from August 13th, 2022 through September 13th, 2022, and one additional video posted on December 22nd, 2022. Dang, all that insanity, and it only went on for a month. Wild. The videos were related to the tragic disappearance, search, and death of a California teenager, Kiely Rodni, whose disappearance became a public controversy. Plaintiff Daniel Rodni is her father, and plaintiff David Robinson is her grandfather. The search and investigation for Miss Rodni garnered worldwide attention from the press and the online community. On August 6, 2022, Miss Rodni went missing after a party at the Prosser family campground. On August 7, 2023, a friend of Miss Rodni's mother started a GoFundMe page. Upchurch began posting about Kiely Rodni on YouTube on August 13, 2022, at which time the whereabouts of Kiely Rodni were unknown. Mr. Upchurch only began posting after the disappearance became a viral international news story. Plaintiffs admit that Mr. Upchurch's posts were made up of his theories about what happened to Kiely Rodni. On August 21st, 2022, AWP, or Adventures with Purpose, and all of the Jared Lysick insanity, discovered a submerged car with a deceased person inside that was more than likely Kiely Rodni. The entire situation with AWP in this situation itself is wild. But you know what? That's not what this video is for. On August 23rd, 2022, the Placer County, California Sheriff's Office made a Facebook post stating that the sheriff's coroner had identified the decedent as Kiely Rodni. It was not until October 13th, 2023, that news outlets began to report the results of the coroner's final report of investigation. We went over that report begrudgingly, but we did, which concluded that the manner of death was an accident. Kiely Rodni was not breathing when she went into that water. That's what the damn investigational report says. Read it yourself. That's what it says. Miss Rodni was missing for over 2 weeks. It took another 2 months until there was any reported answer as to her cause of death. During those 2 weeks, Miss Rodni was missing. The media, in particular social media, was teeming in real time with participants in discussion of what happened to Miss Rodni and whether she was ever at the party. Wait a second. That's the wrong date. So Ryan Upchurch's attorney has the wrong date in here for when the coroner's report actually came out and talked about how the manner of death was an accident. That report came out on October 13th, 2022, not 2023. Probably a better thing that he got rid of this attorney. During the 2 weeks Miss Rodni was missing, the media, in particular social media, was teeming in real time with participants in discussion of what happened to Miss Rodni and whether she was ever at the party. Yeah, I mean, there's lots of questions about if the party was even real. There's no proof of this party. There's no freaking pictures. There's no videos. There's no nothing. Even after all this time, there's nothing. Many, including Mr. Upchurch, took to YouTube to use internet sources, interviews, and local media coverage to try and aid in her return and find answers to the mystery of her disappearance. And that was another thing right here. I agree wholeheartedly with the sentiment of what they are about to say here. So I'm going to read it and then I'm going to go off. Mr. Upchurch offered and paid $100,000 and a Hellcat to anyone who could find Miss Rodni. Now, I don't remember it being exactly that way. As far as I'm understanding, it was supposed to be a Hellcat or it was money. Okay, while I'm editing, I'm remembering how this sort of went. There was a Hellcat that was offered. And then when AWP found Kiely, Upchurch found out they were not getting the reward money. So he ended up giving them the reward money, but that whole thing went really shady. it like didn't go to AWP's account. It was wired to Jared's account personally. And right after all this happened, that's why this dang Kiely Rodni case is so crazy. Right after all of that happened is when everything about Jared started coming out about his court cases and the SA stuff. That's when all that started. And that's whenever AWP fell apart and everybody started leaving. Because then remember, Ryan Upchurch came out basically like demanding his money back, but apparently also gave, I think it was Doug the Hellcat. Dang, there was so much that went on back then, man. But it was such a big reward because this area is full of a bunch of rich kids, a bunch of rich families. There's a lot of politicians here. There's a lot of millionaires, multimillionaires, and their families that either live in this area or vacation in this area. So you can't just put out like a $15,000 reward or even a $50,000 reward and really get these people's attention. You really can't. So to put something so high value out there, yeah, I agree. It was probably something that should have gotten somebody's attention, but it didn't. And the only reason why, to me, it doesn't really matter in a way of, oh, that just means that nobody knows anything and it was really an accident. No, it just means that only probably like one person, maybe two, but probably just one knows the truth and they're not going to rat them freaking selves out, you know? So I don't really know what else to think about that. Because again, there's no proof that this party happened. When you see the cars going in and out of that area on the fire cams, there's not like hella traffic. It's like a sprinkling of vehicles. It's not like party traffic. And even when the cars go to leave, before we then see what's believed to be Kiely Rodni's vehicle going into the water extremely slow, like I swear that damn vehicle is going like 10 miles an hour, if that, before it hits the water and just glides real slow. Like, remember, the windows were open. She could have gotten out. She was athletic. She was thin. There's no way that she couldn't have gotten out, especially with how slow the damn thing was going. But there wasn't party traffic either. So when we heard that like everyone left out at a certain time and there was some other people in the campground that saw everyone leaving, I was really expecting to see like a mass exodus the way that they really actually described it. And we didn't see it that way. It was just a few vehicles. So the whole thing is really suspicious because the story that they gave us, we don't see proof of it being real at all. This belies plaintiff's conclusory statement that Mr. Upchurch, a singer, was somehow using the Rodni debate to make money. But you can still use a topic to get money without making money the way that these people are trying to say he was making money. I don't remember ever having ads on his videos, but it still brings traffic to his channel. It still brings people to his music. It still, at the end of the day, does something. But I also believe that he was really confused about this situation because one of the first things that really caused an uproar was a similar vehicle being seen in a neighborhood not too far from there, and a girl that fit her description, that fit Kiely Rodni's description, being described as running through this neighborhood with like nothing but a bra on, like screaming for help basically. And then we never heard anything again. And then we were told later on that it was basically like a woman that was just having some sort of mental breakdown. I don't even really remember the entire story, but that got a lot of people's attention at first. And then time went on. And then the craziness with AWP finding her exactly where all of these agencies already looked. And we literally watched the scuba divers swimming in the water right where the freaking car was found. Like, it's like somebody had like a teleporter machine and just teleported that vehicle with her body in it wherever it wanted it to be going, because there was no sign of anything. They started looking in that area the very next morning and there were no tire marks that made them believe that a vehicle went into that water. I still just to this day don't really understand how people can keep secrets like this, because you know someone is. It goes on to say, because of a number of facts he describes in detail, Mr. Upchurch ultimately expressed the opinion that the entire story on Miss Rodni was an internet creation and not real, which I full-heartedly believe that she was real and she died and shit's crazy and someone's keeping a secret deep inside of themselves, but that's just me. He expressly stated in one video, "If you were bothering me, do you think I would go in depth for 2 weeks and make all these videos of different angles of scenarios of what possibly could have happened?" Plaintiffs only cite allegedly actionable statements from 6 of the attached 38 videos and 1 additional video. And it goes on to list a bunch of the exhibits. 37 of the 38 videos attached to the admitted complaint were published in a 1-month period from August 13th, 2022 to September 13th, 2022, directly during the time of the search and investigation. The only video Mr. Upchurch posted after that time was Kiely Rodni Only Logic Part 1. There are a few videos left on his channel. I watched them on the 19th. Again, I'm recording this on the 21st. I watched them on the 19th. There's still a few. Mr. Upchurch explained the video was made because he reviewed the case to see if anything new had developed and to explain why he formed the opinion he did. He disclosed again all the information he reviewed and why he reached his opinions. But I will also say, and the video is still out there, one of the videos he did sort of early on in the whole thing, I was following along and trying to clear up what was going on with like that Rodney situation because a lot of people were really confused. So I did what I try to do my best and try to detangle all of the confusion so that people understood who was who, because at that time there was like a white Rodney and a black Rodney. So people were getting really confused and everything needed to be cleared up. Icked Mail walked into the story. It all got cray-cray, all right? That exact same time is around the time that he started just being wild. And he put a video out with like Google Maps and a bunch of other things, and none of it was connecting and it didn't look right. So I went in and I used the exact same tools that he was using and was able to see the fuller picture. And I wasn't really quite understanding how he was seeing things the way that he was seeing them. And he was just like really out there. You could see it in his eyes. And I just knew then I had to like really step away from the things that he was saying and just really, that was my first lesson in don't really listen to other people that are talking about the same thing that you're talking about, because you're going to get pulled into what they're talking about and not really have your own opinion, because it's going to be a little bit led, even if you don't think that it is. So I had to back away from all of that, and we had to just focus on what was really happening. And now here we are. So yeah. It goes on to say, when considering the language of Mr. Upchurch's statements as a whole in the context of those statements, it is clear his statements are protected opinions and often hyperbolic. I still feel like he crossed several lines, but okay. Legal standard. Federal Rule of Civil Procedure 12b-6 permits dismissal of a complaint for failure to state a claim upon which relief can be granted. The very purpose of this federal rule is to enable defendants to challenge the legal sufficiency of complaints without subjecting themselves to discovery. I feel like that should have been like the point of this. I was really hoping that stuff about the case itself would be asked for to prove some of the things, some of the theories that he was saying, but I don't see that happening here. This is critically important in cases impacting the First Amendment, where the filing of a lawsuit alone imposes a chilling effect. To survive a motion to dismiss, the plaintiff must allege facts that, if accepted as true, are sufficient to raise a right to relief upon the speculative level, and to state a claim to relief that is plausible on its face. While the court should accept well-pleaded facts as true in determining whether a facial plausible claim exists, it need not accept as true a legal conclusion couched as a factual allegation. Threadbare recitals of the elements of a cause of action supported by mere conclusory statements do not suffice. And that's from Ashcroft versus Iqbal from 2009. Okay, choice of law. I'm not really going to read this whole thing. I read over it already and my system crashed and I'm having to re-record this portion of it. But it's basically claiming that Tennessee laws should be the laws that are followed in this motion, in this entire lawsuit, because everything that they are claiming is defamation was posted in Tennessee. The case itself was filed in Tennessee. Ryan Upchurch lives in Tennessee. It should follow the Tennessee rules, which I honestly agree with. The crazy part, though, is that down here it states that Tennessee doesn't recognize defamation. Tennessee has a more significant relationship. First, the relevant local laws of Tennessee provide significantly more protections for speakers than those in California, which isn't surprising. Honestly, California is a bit wild. No offense, but California is a bit wild. First, Tennessee does not recognize defamation per se and requires all plaintiffs to plead and prove damage. Now, obviously, they should have to prove it. I agree with that. But to say Tennessee does not recognize defamation, that's crazy. Moreover, Tennessee has a statutory cap to damages recoverable in civil actions, including defamation. The Second Circuit has found in multi-state defamation cases where the defendant's state has special speech protections that states' laws should apply. Here, Mr. Upchurch is an entertainer and artist solely based in Tennessee. It's going to say everything I basically already said. Everything should happen based on Tennessee law. Argument. Plaintiff's claim of defamation per se, invasion of privacy, false light, and intentional negligent infliction of emotional distress are all based solely on statements made by Mr. Upchurch in YouTube videos regarding the mysterious disappearance and death of Miss Rodni. Under Tennessee, California, and Supreme Court precedent, the First Amendment protections, Mr. Upchurch's statements are protected opinion speech. Because the entirety of plaintiff's action against Mr. Upchurch is based on his constitutionally protected speech, each cause of action should be dismissed. And then they just quote somebody quoting somebody else from something else, and that's basically this entire paragraph. As explained herein, Mr. Upchurch's speech fits within a protected category of speech as his statements are opinions that cannot be reasonably construed as stating actual fact. But that's the problem. There are hordes of his fans, his creakers, his creek squad, that believe everything this man says. And he sits there and he states the things that he is stating as if they are actual facts when indeed they are opinion. And it's not like what we do when it comes to pulling up a court document and saying, okay, this is my opinion based on this very factual thing that was found at the state lab that's listed as evidence. No. This is all a bunch of stuff he made up, stuff in his mind, stuff he pulled out of his butt, all right? And again, thousands of people believed it as fact. That's why it became such a big issue. There are a lot of people that sit there and kudo this man, no matter how ridiculous and unhinged he sounds. It's very unhealthy. Plaintiff's amended complaint should be dismissed because Mr. Upchurch's statements are protected by the First Amendment, California law. Number 1, Mr. Upchurch's statements are not stating fact, but instead opinion. Plaintiff's amended complaint incorporates by reference and by attachment 38 YouTube videos, which they allege are related to and or contain defamatory statements made by Mr. Upchurch. Only the statements plaintiffs chose to set out and allege in the amended complaint, however, should be considered by this court. I mean, yeah, they have to actually be citing it in order to use it. That makes sense. It is not the court's responsibility to speculate about potential inferences that plaintiff might be trying to make. It is plaintiff's duty to assert clear allegations in his pleading. Under California law, defamation requires the intentional publication of a false statement of fact that has a natural tendency to injure the plaintiff's reputation or that causes special damage. The elements of a defamation claim are 1, a publication that is 2, false, 3, defamatory, 4, unprivileged, and 5, has a natural tendency to injure or causes special damage. The standard under California law for a private individual to prove defamation is negligence. However, if the person defamed is a public figure, he must show by clear and convincing evidence that the defamatory statement was made with actual malice, that is, with knowledge that it was false or with reckless disregard of whether it was false, meaning you knew it was fake, you knew it was false, and you put it out there anyway because you don't care. You don't give a damn. Opinion speech has long been held as broadly protected by the First Amendment. Based on these principles, California courts have found that the sine qua non of recovery for defamation is the existence of falsehood. Because the statement must contain a provable falsehood, courts distinguish between statements of fact and statements of opinion for purposes of defamation liability. Although statements of fact may be actionable as libel, statements of opinion are constitutionally protected. It then gives a quote from Sanders versus Walsh from 2013, where they're actually quoting Wong versus Jing from 2010. While statements of opinion do not enjoy blanket protection, the critical question is not whether a statement is fact or opinion, but whether, as a reasonable fact finder could conclude, the published statement declares or implies a provably false assertion of fact. California courts use a totality of circumstances test of whether the statement in question communicates or implies a provably false statement of fact. For words to be defamatory, they must be understood in a defamatory sense. He knows what he said in the way that he said it. Like, come on. Next, the context in which the statement is made must be considered. He knows the context. Let's be so serious. This crucial question of whether challenge statements convey the requisite factual imputation is ordinarily a question of law for the court. Based on Mr. Upchurch's language and the context, no reasonable fact finder could conclude he declared or implied a statement of fact. That's the thing, though. Like I said, most of the people that follow him, they don't care to go out and do their own research. They take everything that he says and they run with it. They believe him. They don't try to find fact. They don't try to prove what he's claiming. They don't try to find a secondary source. They just believe him and they run with it and they put it on every other platform and they go and they bombard other comment threads on other creators and different YouTube videos and they spew it over and over again. And it also is a huge game of telephone because they also take what he says, as insane as it already sounds, and they put their own insanity on it, and then everything is everywhere. The ripple effect is wild. The specific language of Mr. Upchurch's statements shows he is not asserting an objective fact, but instead opinion. When considering the language of the statement itself, courts look at whether the purported opinion discloses all of the facts on which it is based and does not imply that there are other unstated facts which support the opinion. If the opinion discloses all of the facts on which it is based and does not imply there are other unstated facts which support the opinion, the statement is defamatory only if the disclosed facts themselves are false and defamatory. Additionally, when examining the language of the alleged defamatory statements, courts consider whether the statement was cautiously phrased in terms of the author's impression. The Dickinson court reversed the trial's court's order granting the motion to dismiss. The court found that the statement was not phrased cautiously in terms of opinion. Although not dispositive, the court found notable that the statement did not indicate it was the defendant's belief, and further, that the defendant did not disclose the facts on which it was based. Instead, the defendant's unqualified statement was that the plaintiff was a liar, a fabricator, and was giving false information about being R-worded, which a reasonable fact finder should find was false statement of fact. Side note, because I'm really curious as to how my audience feels about this. You guys know how I feel about the DP, so you should know how I feel about this one, but I'm still really curious as to y'all's opinion. If a woman or a man, if anybody, claims that they were assaulted in any way, shape, or form, especially R-worded, okay, and it's a false allegation, should they then be charged with the exact same amount of time that the person that they accused would have gotten if they would have been found guilty of something that they didn't do? I believe so. I believe so. If not more, I think they should probably be punished more if they're lying. But I'm curious as to what you guys think. The court also found it important that the publication was authored by someone with firsthand knowledge and explained that the result in the case might have been different if the same statements were published by a person with no firsthand knowledge. Now, again, this is not talking about this case specifically. This is talking about the Dickinson case. The court explained, the R allegations against Cosby were a subject of national attention and much public speculation. It would perhaps be unactionable opinion of an unrelated individual with no actual knowledge of the R chatting in a public forum were to say, Dickinson lied about the R after all. She told a different story in her book. That may be unactionable opinion because it is based on disclosed facts and the speaker would not be presumed to be basing the opinion on anything else. If a person comes out on the stand in court and tells one story and then the court system is done and over with, there's been justice and whoever was the person who was being accused is found guilty and there's a sentence happening and then they come out and write a book and it's the complete opposite of what they testified to, that's a huge issue. That's a huge issue. So I find that that's a very important situation that they should probably handle a very certain way. They go on to cite Carr versus Warden, something to do with a planning commission. When considering the language in and surrounding the alleged defamatory statements, it is clear Mr. Upchurch is asserting protected opinions and not facts. The statements at issue, as set out in the amended complaint, are set out in these paragraphs. I'm not going off on all these numbers. Plaintiffs allege that the statements amounting to defamation are Kiely Rodni was not real. Plaintiffs were not real. Well, they're suing you, so they must be pretty real. Miss Rodni was a blank person. Miss Rodni's disappearance was a scam to raise money on GoFundMe. Plaintiffs were involved in a GoFundMe scam which imputed criminal activity. Plaintiffs were in fact relatives of a person named Kiely Ross, implying that the plaintiffs were actors pretending to be someone other than they in fact were. Where is Kiely Ross? He, Upchurch, took this chick's photos, videos, all the things, and posted them in a video talking about how Kiely was Kiely and all the things. All right, we talked about this already. Where is this person? I want to see them in their lawsuit. Number 7, plaintiffs were involved in a scheme to catfish fake a death. And yeah, that was one of the things, that it was all fake, that she didn't really die, that she was a fake person, all the things. See, I, again, and the majority of my viewers are under the assumption that somebody is lying about what happened to Kiely, that she was very, very real, and someone very, very real is out there with the very, very real truth and needs to be serving some very, very real prison time. That's the side we are on here. Plaintiffs further allege that Mr. Upchurch's statements amounting to defamation per se are 1. Comments accusing plaintiffs of participation in a GoFundMe scam, which statements accuse plaintiffs of committing acts of moral turpitude, including fraud. 2. Comments accusing plaintiffs of participation in a GoFundMe scam while pretending to be Kiely Rodni's family, which statements falsely accuse plaintiffs of crimes of moral turpitude. How the lawyer is reading this and still thinks that this is just an opinion is honestly wild to me. Sorry, not sorry. This is where I said he crossed a line. Finally, plaintiffs allege that the statements supporting their false light invasion of privacy claim are 1. Accusing plaintiffs of participating in a scam to profit from GoFundMe, 2. Accusing plaintiffs of having misrepresented themselves and their identities, lying about who they are and who their loved ones are, 3. Accusing plaintiffs of being fake and not real while grieving the tragic death of a loved one whom Upchurch also referred to as a B person, fake and not real. Number 4, calling plaintiffs fake and not real in the days after their granddaughter suffered a tragic fatal accident. As explained in Supra, these are the only statements the court should consider. As explained herein, however, other statements in the videos cited in the amended complaint help establish the protected nature of Mr. Upchurch's commentary and are therefore cited herein. The statements as to Miss Rodni and plaintiffs not being real, them being other people, or statements about GoFundMe are clearly only his opinion formed based on facts he disclosed. No, he didn't have any facts to prove that Kiely Ross was Kiely Rodni. The people that he was using and trying to say were like the same people, if you seriously needed glasses, you could still tell that the people did not look the same. And I'm sorry if that offends you, but come on. Like, you see the way that these people, again, just hang on to every word without questioning anything. And just because this guy can put some words together and put some sounds together and make a song that sounds decent does not mean that he is a good person to be following the footsteps of. I mean, literally look at Jared Leto. Even Elvis Presley is not so shiny. If you know, you know. In addition, Mr. Upchurch never opined that plaintiffs were involved in any type of scam, which will be addressed in Section V. Yes, they did. Yes, he did. That's exactly what the hell he said this entire time. What? Okay. First, Mr. Upchurch is like the hypothetical defendant the Dickinson court discussed, one without any personal knowledge. Also, in each of his videos, Mr. Upchurch walks through and shows the listener the information that leads him to his opinions. And again, I did a complete video walking through everything this dude was saying one time and debunked everything that he said in that video. Literally everything with his own tools. The video is still on my channel. It's way back in the day. It's like 3 years old. In fact, the amended complaint directly alleges this process. In this video, Upchurch played a video of law enforcement's press conference. Upchurch then commented, and it just tells you where the comment is cited in the attachment stuff. This video was a phone screen recording of Upchurch performing internet searched relating to Daniel Rodni. Performing internet searches relating to Daniel Rodni? Come on, guys. Upchurch zoomed into a pixelated image, which, per the title of the video, he claimed was another picture of Kiely's CRV. I think this is the one where he tried to say there was a photo of this in like Google Maps, I think at Daniel's house, maybe? Something like that. In this video, Upchurch posted photographs of plaintiff David Robertson with quotation marks around the phrases Kiely Rodni's grandpa and Kiely's grandpa, because he was trying to say that Kiely's grandpa, the guy who is Kiely's grandpa, is actually somebody else that's related to the Kelly Ross girl. In fact, in every video in which Mr. Upchurch makes statements alleged in the amended complaint to be defamatory, as well as the other videos attached to the amended complaint, he demonstrably is forming that opinion based on reports, statements, photographs, interviews, and information that he discloses to his audience. Yes, but honestly, again, discloses to his audience knowing they're going to hang on every word without really looking at it themselves. Let's be serious. Because of this, Mr. Upchurch's viewers are able to draw their own conclusions based on these disclosures, but they don't. I always give you court documents, links to real things, and tell you, do not just listen to me. Go out and look for it yourself. Go out and do your own due diligence. He doesn't do those things. He knows he's showing you things that do not match up, and he knows that people are going to believe it. At least a huge majority of people are going to believe it. Viewers are certainly not led to think that Mr. Upchurch is presenting objective assertion of facts rather than his opinion on facts that they have an equal opportunity to analyze. That's not true. They believe him because he has money, he has connections, because of who he is in the music industry and the people that he knows. They're expecting the things that they hear come out of his mouth to be accurate. Let's be serious. Let's be actually serious about the reality here. On August 13th, 2022, Mr. Upchurch posted his first video discussing the disappearance of Miss Rodni and introduced himself to the true crime community. But there was no introduction needed because he'd gotten into the true crime community in other cases. I believe he even talked about Summer Wells before. Mr. Upchurch makes clear that he is a singer, not a true crime YouTuber, and that he is only giving scenarios of what could have happened. I know a lot of you true crime people think you're effing Inspector Gadget, and I'd love to break it to you, and I am. You're not, and guess what? I'm not either. But in the past, I've gave plausible, realistic scenarios that other people have not given, meaning he's come up with crap out of his butt and thrown it out there, and he thinks that it's special because no one else is crazy enough to say the crap that he says. And which is why a lot of these true crime people are like, boo, stop, you can't do this, you're a singer. No, I don't really care that you were a singer. If you were coming out here and saying things that made sense and weren't trying to just cause a bunch of chaos, it wouldn't have mattered. Mr. Upchurch also recognizes that others are putting forth theories as well. He acknowledges that there are many people posting discussions of Miss Rodni's disappearance and that he has been watching their videos. I've already seen some ridiculous theories. If you do want to see the timeline perfectly, I suggest you go to the YouTube page of a lady named Plunder. Yeah, so her fake Jesus picture can stare into your soul. She has the full breakdown on her page. I just want to point out odd stuff. So he's sitting here doing all of this about true crime people while telling his people to go watch a true crime person. He was also hopping and skipping all over panels of true crime people too, while sitting here making fun of true crime people. He has sat here and done the same thing that, in my opinion, Crime Circus does in true crime, which is make a mockery of it. I don't feel like either one of those people take these things seriously. And again, that's just my opinion. Mr. Upchurch painstakingly discloses all of the facts and information he is seeing and hearing about the disappearance in real time that leads to what he thinks and his opinions. When the video is viewed in its entirety, there is but one conclusion. Mr. Upchurch does not purport to have any firsthand knowledge of anything and is merely giving his possible scenarios. That's not what he's doing. That's not what he's doing. The same can be said for each of Mr. Upchurch's videos. In his August 29th, 2022 video cited by the plaintiffs, Mr. Upchurch is expressing his opinion and speculating. He says, "Show me that it's real. Show me proof of Kiely Rodni." Well, she's dead. So there's that. When looking at the entirety of the language in Mr. Upchurch's videos that surrounds the alleged defamatory statements, there is nothing about the language in Mr. Upchurch's statements that would allow a fact finder to find he was expressing a fact. As Mr. Upchurch says in one of his later videos, "I still think the same exact thing. I still think it's B. I guess bullshit." Still not buying it. Just not. Well, you can't also sit here and claim that Xana May and the American Dream Catcher or whatever freaking dude that was checked in certain places and interviewed Sammy and all the things are trafficking somebody who then you in turn claim is not a real human. That's not, that's not logical. This language certainly clarifies that his statements, even when made assertively, are hyperbole and opinion. It gives an example here where it was stated, I don't think Jagger did anything. I think Kate Kuno is innocent as well. I was getting frustrated and started going through this case from the beginning. It's all bullshit. You know, with all these crazy leads, we've been getting to rabbit holes. It's been like a reality show from the beginning. Well, that's because you're inserting things that aren't real. Stop doing that. Such cautionary language is even evident within the alleged defamatory statements set out in the admitted complaints. Let's be honest with ourselves. At this point in the video, there is nothing to lead me to believe that this person is real. The Kiely Rodni person. There is nothing that shows me she's real yet. Mr. Upchurch is asking for proof that indicates the situation is real. But have you asked for her birth certificate? Have you asked for medical records from whenever she was born? I know that there's like HIPAA and everything, but if you're going to do medical records of Daniel Rodni, why are you not doing medical records of Kiely Rodni and making it attorney only? Why are we only seeing a bunch of jabby boo-boo that's not really making any sense or proving anything? This is just like the situation, and I know that this is going to like go to the left, but this is just like the situation that's going on in France with Candace Owens saying that whoever the guy is from France, the wife is actually a man. And instead of just doing a damn blood test and freaking looking at the chromosomes and the damn blood work, they're like submitting photos of the fact that she's a woman. I don't even want to know what the frick that even means. Why would you choose to submit photos of your womanhood to the court instead of just taking a simple blood test to prove that you're a female? To me, it's like the exact same freaking thing. Just this whole Mr. Upchurch is asking for proof that indicates the situation is real made me think about how ridiculous that situation is. Because again, in this one, why aren't we seeing very specific and certain things being asked for? It doesn't matter if Lindsay is on this case or not, which obviously she isn't. But Daniel is. That's Kiely's biological father. He would have every right to be able to sign off whatever he needed to sign off on in order to get those medical records, proof of birth. So why are they not asking for that stuff? That doesn't make sense to me. B, the context of the statements also show the statements are opinion. When considering the context of the statement, courts look at facts, including the audience to whom the statement was directed. Seriously, that's the biggest problem. Because again, for the 20th time in this video, and probably the millionth time in 3 years, the majority of his audience just latch on to everything that he says as fact, and they run with it and they spread it like insanity. That's the facts. Consider how the average reader of the statement would reasonably have understood it. They're not average readers. The forum in which the statement was made. Anonymous misspelled rants on an internet board devoted to rants and raves are generally not expected to be taken seriously. That's not what this is, though. That's not at all what this is. Another example is Franklin versus Dynamic Detail, stating, finding it significant that the author did not purport to be a lawyer, stating opinions as legal truths in legal verbiage. Well, that's like, that doesn't even make any honest sense to this entire situation. So then they go on to talk about Dickinson again. Another factor to consider in the context portion of the totality of the circumstances test is whether that statement is so-called predictable opinion. Under the totality of the circumstances test, courts examine whether the statements were made by participants in an adversarial setting. I mean, he's pretty damn aggressive. And that's me saying that, so okay. Where potentially defamatory statements are published in a blank setting in which the audience may anticipate efforts by the parties to persuade others to their positions by use of epithets, fiery rhetoric, or hyperbole. Language which generally might be considered as statements of fact may well assume the character of statements of opinion. The California Court of Appeals considered a case in which the defendant posted on rants and raves section of Craigslist. Okay. Craigslist, an advertisement's website, we know, which contained 21 alleged defamatory statements. And then it just goes on to talk about what this guy was talking about, something to do with the bank. I don't care about any of this. It has nothing to do with the actual case itself. So let's just go down to this paragraph here. Mr. Upchurch's comments are certainly published in a similar setting with a similar expectation of the audience. No, they're not. Like, this lawyer is straight up lying through her freaking teeth. To begin, his statements are made on his personal YouTube where, as stated in the admitted complaint, Mr. Upchurch is known primarily as a musician. That means it's not personal. It's his business. That's his business. That's his livelihood channel. So that's not being honest at all. Plaintiffs further allege that Mr. Upchurch's videos pertinent to this case were made as part of the growing industry of true crime sleuths who began wildly speculating as to what really happened to Miss Rodni. This YouTube world in which he was participating is certainly one in which an audience would expect fiery rhetoric, or where publishers lack the polish that would lead a viewer to expect to hear assertions of fact, much like the rants and raves section in Summit. No. Maybe a percentage of them, but do not lump us all together. You are more dumb than I thought you were. Additionally, the titles of Mr. Upchurch's YouTube videos show that the videos are clearly to be taken in the context of asserting opinions and theories rather than defaming facts. That's not true either. This person is like really going to make me believe they've never literally watched any of this stuff. The example is the Kiely Rodni case, Conspiracies Gone Wild, at Upchurch Official. Exactly, at Upchurch Official. This is not a personal page. How is this not a red flag in Kiely Rodni missing? Exactly what I think happened to Kiely Rodni. All of Mr. Upchurch's videos contain the same elements of drama, hyperbolic language, and heated debate that would certainly give the audience the impression Mr. Upchurch was not asserting objective fact. No, that's not true. They can underline think all they want to. He crossed a lot of lines. A lot of lines. Mr. Upchurch is not presenting his statements with any indication of private and personal knowledge or authority on investigations, but he is, because he's claiming somebody came to his house and told him all these things. And that he had all this proof because he had all these people with all these connections that could find him all this information. So again, did this person watch any of this stuff? The context of the YouTube true crime heated debates show Mr. Upchurch's statements rise to predictable opinions when examining the full context. As explained supra, Mr. Upchurch's statements were made in the midst of what became a very long and heated conversation about what could have happened to Miss Rodni. Not only were people involved in trying to find answers on their own, but were involved in trying to promote or dismantle other YouTuber theories. In sum, the alleged defamatory statements in plaintiff's amended complaint are all protective opinion speech. Both the specific language and context of Mr. Upchurch's statements weigh heavily in favor of finding the statements set forth in the amended complaint as unactionable. Thus, if California law applies, plaintiff's defamation claims must fail. Moreover, because the gravamen of every count in the amended complaint is Mr. Upchurch's speech, and that speech falls under First Amendment protection, every count should be dismissed. B. Plaintiff's amended complaint should be dismissed because Mr. Upchurch's statements are protected by the First Amendment. Now they're going to quote Tennessee law. The analysis of the nature of Mr. Upchurch's claims is substantially similar under Tennessee law, and thus this court should find that the statements are protected opinion regardless of the choice of law. Under Tennessee law, whether it be slander or libel, in order to establish a prima facie case of defamation, a plaintiff must establish that the defendant communicated defamatory matter to a third person with knowledge of its falsity or defamatory nature to the plaintiff, reckless disregard for the truth of the statement, or negligence in failing to ascertain the truth of the statement. And it goes on to cite Sullivan versus Baptist Memorial Hospital from back in 1999. Finally, a plaintiff must also allege and prove that the defaming party communicated a false or defamatory statement concerning the plaintiff. In Tennessee, the issue of whether a communication is capable of conveying a defamatory meaning as a question of law for the court to decide in the first instance. It is then for the jury to decide whether the communication was in fact so understood by those who received it. In making this determination, a court must look to the words themselves and is not bound by the plaintiff's interpretation of them. Tennessee, in accordance with Supreme Court precedent, has recognized that pure opinion, hyperbole, or rhetorical exaggeration are not capable of defamatory meaning. It goes on and has a statement about Moses versus Roland, about how somebody was threatening somebody. Again, I'm not going to read it. It has nothing to do with this case. Moreover, like California, Tennessee recognizes that a statement in the form of an opinion is actionable only if it implies the allegation of undisclosed defamatory facts as the basis of the opinion. Thus, because a defamatory statement must be factually false in order to be actionable, comments upon characterizations of published facts are themselves not actionable. Accordingly, a writer's comments upon true and non-defamatory published facts are not actionable, even though they are stated in strong or A terms. These comments have been given constitutional protection under the First Amendment. Thus, as argued supra, given the context and language of Mr. Upchurch's statements, it is clear that they are protected opinion and hyperbole speech under Tennessee law. Therefore, if Tennessee law applies, this court also should not only dismiss plaintiffs' defamation claims, but the remainder of their claims, as the gravamen of each claims lies within the protected speech. C. The majority of the alleged defamation statements are of and concerning plaintiffs. The only statements that specifically refer to plaintiffs are statements in these paragraphs. None of the others are of and concerning the plaintiffs. In actions concerning allegedly injurious statements, the First Amendment also requires that the statement on which the claim is based must specifically refer to or be of and concerning the plaintiff in some way. Basically saying that Kiely Rodni is not a real person is definitely something that would directly be concerning of the father of that person, right? I mean, that's a little crazy. This requirement confines actionable defamation to statements made against an ascertained or ascertainable person, and that person must be plaintiff. Thus, a claim for defamation based on an alleged statement that does not expressly designate its subject will survive a motion to dismiss only if it is alleged that the statement was made of and concerning the plaintiff or referred to the plaintiff by reasonable implication. In Steele, 3 female employees of adult entertainment businesses and cabarets sued the defendant for stating that almost without exception, these girls were SA'd by a family member and have addictions to substances or drinking. These clubs feed on that, basically claiming that if you are in the adult entertainment industry whatsoever, you have to have some sort of addiction issue. You have to have some sort of SA in your background. You have to have been, something had to have happened to you tragically, which is honestly a stigma. A lot of them follow that. That's just how the world works. But it's interesting that they can consider that defamation, or somebody was trying to make that defamation, when that's honestly, I mean, that's a lot of people's stories. It's just going off of what we've learned through life and listening to people. The complaint, however, did not include an allegation that the plaintiffs were those girls. Although the Court of Appeals did not adopt this rule, the Steele trial court expressly relied on what it termed the group libel rule. Under the group libel rule, plaintiffs must allege that they were individually named in the alleged defamatory statements. Statements that are used broadly concerning the members of a class or group, absent other circumstances specifically pointing to a particular member, are not a sufficient basis for one member to have a cause of action for libel or slander. The Court of Appeals affirmed the trial court's grant of the motion to dismiss because the statements in this complaint do not expressly mention the plaintiffs, and there were no allegations that the statement referred to the plaintiffs by reasonable implication or that it was made of and concerning the plaintiffs. Meaning a statement was made and these people took it personally. That's not the same thing that's going on here. That's not the same thing that's going on here whatsoever. And this next statement is technically a lie, but also not a lie at the exact same time. The GoFundMe scam comments made by Mr. Upchurch are not targeted at the plaintiffs. In Mr. Upchurch's very first video on the disappearance of Miss Rodni, he mentions GoFundMe. He distinguishes himself from the true crime community by saying you will not see him put a GoFundMe link at the bottom of his videos like others do. Okay, but it was for the family. It had nothing to do with us as creators. It was us trying to share support for the family. So if you don't want to do that, then I don't know what to tell you. Even in the Idaho 4 case, I have shared the Consalvases stuff before I had issues with everything. We shared Laramie's, we shared Mogan's, we shared Kernodles, we've shared all of them in order to support the families as best as we could. And that has happened in every single case. So that's a really strange statement. I'm not going to put a GoFundMe link at the bottom of my videos like others do. Well, you're not going to support families the way that others do? Okay. But I said what I said because the plaintiffs are not Lindsay. And Lindsay and her husband, which is Kiely Rodni's stepfather, and the grandfather, that's technically the plaintiff, all of the GoFundMe stuff was sort of like on that side of the camp, but not at the same time. Like, I believe it was somebody in Lindsay's camp that actually put that GoFundMe out there. And again, Lindsay is not part of this case. So it's a lie, but it's not a lie at the same time. One thread that runs throughout his videos in his disagreements with the true crime community. Even with respect to Miss Rodni's family, the GoFundMe in question was set up by a friend of Miss Rodni's mother, who is not a plaintiff in this case, and neither is Lindsay. Mr. Upchurch never ties his GoFundMe opinions to the plaintiffs, but that's just because Lindsay isn't on the case. But it still had everything to do with that family. So it's like, right but wrong at the same time, like I said. Furthermore, plaintiffs make no non-conclusory allegations that such statements implicate plaintiffs in wrongdoing. There is no implication of who was involved in any such alleged scam, let alone the plaintiffs. Thus, this court should dismiss the plaintiff's claims against Mr. Upchurch that are based on these statements as they are not of and concerning plaintiffs. I don't agree with that, but that's just me. D. Plaintiff's defamation per se claim should be dismissed because plaintiff's allegations do not support that Mr. Upchurch accused plaintiffs of crimes of moral turpitude. The amended complaint alleges that Mr. Upchurch is liable to plaintiffs for defamation per se under California law because he accused plaintiffs of involvement in a GoFundMe scam, and they always put it in quotations, and thus implicated them in committing acts of moral turpitude, including fraud. First, as argued supra, should Tennessee law apply? This claim should be dismissed on its face because Tennessee does not recognize defamation per se, and that's the only reason. Okay. However, should California law apply? This claim should still be dismissed for, despite plaintiff's portrayal of Mr. Upchurch's statements. It is evident that Mr. Upchurch did not accuse plaintiffs of participation in a GoFundMe scam, fraud, or any crime at all as alleged in paragraphs 140 through 141. Thus, this claim should be dismissed. That's not true. You put pictures of Kiely Rodni's grandfather up on your videos about Callie Ross, claiming that he was actually a relative of Callie Ross, and Callie Ross was really Kiely Rodni. So this is not true. This is not true whatsoever. Plaintiffs charge Mr. Upchurch with slander per se under California Civil Code 46. Code 44 defines defamation as either libel or slander. 46 provides in pertinent part, slander is a false and unprivileged publication, orally uttered, and also communications by radio or any mechanical or other means which charges any person with crime or with having been indicted, convicted, or punished for crime. Not really. Because slander is something that somebody is saying that's an allegation that, in my opinion, can't really be proven. If you say something and then you can pull up a document and be like, this dude was never arrested for this, what are you talking about? Someone is lying, and that's not really going to cause harm to someone's reputation because it can be proven instantly not true. So to me, and again, this is just me and my layman brain, okay? When it comes to something that is considered slander, to me, it should be something that you are being accused of, that they can't prove, but that still causes harm. Like someone being accused of SA or R or doing something with a child that there's no proof of. And there's a lot of people that get accused of doing those things that haven't done anything wrong. Okay. A lot of people. So you have to be really careful with those things. But again, if someone is saying someone's been punished for a crime, someone's been indicted of a crime, someone's been convicted of a crime, and it's not true, if they know that it's not true because they can pull up the freaking criminal history, then it's not doing any harm to that person who it's being said of. It's doing harm to the person who's claiming it because they look stupid. But that's just my brain. Here, plaintiffs allege that Mr. Upchurch made statements that charge plaintiffs Daniel Rodni and David Robertson with a crime of moral turpitude. There are no statements in the amended complaint that do any such thing. As set forth supra, the opinions on GoFundMe are not of and concerning plaintiffs. Technically not true, but still true at the same time because Lindsay's not part of the case. Mr. Upchurch's opinion statements that plaintiffs were not real, which have nothing to do with any crime of moral turpitude. Yes, it does. You're claiming that they are faking this person being alive, being missing, and being dead in order to gain sympathy and in turn to gain money off of the situation. That's exactly what you're doing. That's exactly what you're doing. R published several videos after Mr. Upchurch proposes his GoFundMe scam scenario and unrelated to them. That's not true. Plaintiffs do not set out one instance of Mr. Upchurch alleging that plaintiffs themselves were involved in any scam or fraud. Again, Callie Ross when it comes to the grandfather, who very much is on this case. E, plaintiffs fail to state a claim for false light invasion of privacy, Tennessee. The Tennessee Supreme Court expressly recognized the separate tort of false light invasion of privacy in 2001. It initially defined the tort as set forth in the Restatement of Torts: one who gives publicity to a matter concerning another that places the other before the public in a false light is subject to liability to the other for invasion of his privacy if the false light in which the other was placed would be highly offensive to a reasonable person, and the actor had knowledge of or acted in reckless disregard as to the falsity of the publicized matter and the false light in which the other would be placed. It only matters if it's not true. Quoting Restatement Second of Torts, the court determined, however, that the appropriate standard for false light invasion of privacy claims asserted by a private plaintiff regarding a matter of private concern is simple negligence. For all other false light claims, in particular those asserted by a plaintiff who is a public official or public figure, or for claims asserted by a private individual about a matter of public concern, the actual malice standard applies. Mr. Upchurch's statements are a matter of public concern. I mean, honestly, yeah, his instability is a matter of public concern. Thus, plaintiffs must allege mutual malice to avoid dismissal on their false light claim. A matter of public concern in this context is a matter of political, social, or other concern to the community. There, the court found that defendant, a developer of a large residential community, again, this is an example, was a private individual who made statements of public concern when he posted a negative online review about a different subdivision, calling it a bait and switch. That's not defamatory. If you have proof that people were moving into that place, spending all kinds of money, and then instantly their houses were falling apart, these were literal tort claims. There were millions and millions of dollars paid out, proving that these companies were building these houses like absolute crap, making people come in and thinking that they were getting such a great deal. They looked beautiful on the outside, but within like 6 weeks, just a few months, plumbing, walls started crinkling, stuff started coming out of the ceiling. That was a real situation here. Here, Mr. Upchurch's statements are discussing a matter clearly of immense public concern to the Truckee and ultimately global community. Thus, plaintiffs must adequately allege actual malice to support their false light claim. But you can only be claiming that there is a statement that discusses a matter of immense public concern of the Truckee and ultimately the global community if you really are trying to believe that this is a real person who you are claiming has been tracked by someone. Not that she's a fake person and this entire thing is not real. You cannot have it both ways here, and that's exactly what he's been trying to do. The actual malice standard is a subjective one in which the ultimate question is whether the defendant made the statement with knowledge that the statement was false or with reckless disregard for the truth. I think we all know the answer to that. To make a statement with reckless disregard for the truth, a defendant must have made the statement with a high degree of awareness of probable falsity. He did. Or must have entertained serious doubts as to the truth of his publication. Furthermore, a plaintiff must establish actual malice with clear and convincing evidence. Here, while plaintiffs assert the falsity of Upchurch's statements, their challenges to the statements fail to illustrate actual malice. That's your opinion. Upchurch offered outlandish theories of the truth of what happened to Kiely Rodni. Upchurch falsely claimed that example at number 42. Upchurch thus has a pattern of publishing reckless false views. I mean, that's not false either. He has a lot of drama that he puts himself in constantly. There's constantly some sort of argument going on with some other artist or something like that. It's constant. Let's be serious. It's all the time. Plaintiff's amended complaint does not rise to the heightened pleading standard for actual malice. Finally, even under the negligent standard, plaintiff's claim fails. As explained in Supra, the statement upon which plaintiffs base this claim are protected opinion. Thus, this claim should be dismissed. F. Plaintiff's false light and intentional negligent infliction of emotional distress claims should also be dismissed under California because they are redundant. Under California law, plaintiffs' claims of false light and intentional or negligent infliction of emotional distress are based on the same alleged conduct as their defamation claims. They should therefore be dismissed as redundant. Here, in essence, plaintiffs' infliction of emotional distress claims are merely alternative legal theories for holding defendants liable for the same conduct underlying plaintiffs' defamation claims. Conclusion. Finally, for all of these reasons, Mr. Upchurch respectfully requests this court dismiss plaintiff's amended complaint under Federal Rule of Civil Procedure 12b-6 for failure to state a claim for which relief cannot be granted. Yeah, I really just feel as if this is crap. Again, he knew that the majority of his fan base, because again, he is a musician, when you are followed as a musician, you have a different kind of following. He's not stupid. Ryan Upchurch is very strategic in the games that he likes to play. Let's be serious. So he knew what he was doing when he put this information out there, when he claimed the things that he claimed. He knew that his fans were going to go out and go crazy, harass the family. I mean, some people even went directly to them in person to start the drama. There's no way that he doesn't know that he has that kind of power. He talks about it all the time. He's very, very arrogant. Now, this motion to dismiss was denied, but it took like almost 7 months. It wasn't filed until May 21st of 2024. Took a long time, and it's 10 pages. So I'm going to read this to you in a separate video. Again, I'm trying to get caught up before the 24th so that we know what's going on. We are up to date with everything. And once that happens and we have a trial date set, if it continues on, we'll have a gist of the way that this is going to go. So we'll go over what the judge had to say in another video, but I want to know what you guys are thinking so far down in the comments about this, because like I said, I was really on board with what Ryan Upchurch was trying to do at first until it seemed like he went off the freaking rails. And it just became to where I could not in good conscience still follow along with his rhetoric, because it was getting disgusting. It was getting ridiculous. It was getting dangerous. And again, he had some good points for a while, but when he started bringing in YouTubers that had nothing to do with any freaking thing, when he started saying that Callie was Kiely and everything was fake, while also again claiming she was being trafficked by Exanime and all these other people, like, you cannot have it both ways, broski. You just can't. And I understand that he apparently came out and like took back the whole, oh, she's fake thing, but did he really? Because we're still sitting here standing on this lawsuit where that's very much still being claimed by his own people in his own motion to dismiss. So I don't know. Let me know what you guys are thinking about all this crazy stuff down in the comments. If you like the way that I present this information and give my opinion, please don't forget to leave a like on the way out. Subscribe to the channel if you have not subscribed already. And please don't forget to make sure that the notification bell is set to all so you don't miss any of my rants, reviews, reactions, updates, or deep dives. See y'all.